Welcome back, everybody. You're watching Law and Crime. This is the Wallace Bradsher case in North Carolina. It's basically an official corruption case. That defendant sitting in the chair that you just saw before the camera panned up to the seal, it's a former defense attorney who then ran for district attorney. He was elected. He was wildly successful, apparently, but eventually there was a question as to why he was hiring his wife, who had worked with him in private practice. People started looking around. The neighboring district attorney, Craig Blitzer, then wanted to hire his own wife, and when the ethics authority said, you folks can't be hiring each of your own wives, they came up with a plan, allegedly, to crisscross and hire one another's wives. And one of those two wives, the wife of the cooperating defendant in this case, was just on the witness stand for close to an entire day's worth of testimony in this case. Again, Craig Blitzer, the cooperating prosecutor, was charged. He turned state's witness, gave up his law license, and keeps pointing the finger back at this particular defendant, Wallace Bradsher. So, look, this is a soap opera, and it is unfolding in this court of law in North Carolina. You just heard the judge say they're going to take about a 15-minute afternoon break here. So let's break this down a little bit more. David Katz is an attorney. He's joining us here on the Law and Crime Network. David, good to see you.
Very good to see you. Nice to be here.
Yeah, so what do you make of this? I mean, just trying to keep the names and the dates and everything straight. You've got Wallace Bradsher. He's the defendant. He used to be a prosecutor. You've got Craig Blitzer. He's a cooperating defendant. He's going to get off pretty scot-free in this without facing any really serious charges. He admitted to one. Apparently, they're really not going to punish him in return for his testimony. And we learned yesterday that authorities basically are not punishing this wife who was just on the stand. She's the one that was going to school while she was getting paid a full-time salary. A lot of people are sitting there saying, wait a minute, she's the one that they should be going after. She's the one that was reaping the real benefit here.
Well, as a criminal defense attorney myself, I guess I have some sympathy for the person who's being charged. And in terms of charging somebody who's not even charged, I guess we'll wait and see, what the evidence, what the testimony against her is. And you wonder sometimes about the prosecutorial decision that they're charging this one or they're not charging that one. But certainly when you look at the defendant, Aaron, he's lived every kind of experience a lawyer can live, hasn't he? He's been a successful criminal defense attorney. He's been a successful campaigner and politician who won the office of district attorney. Then he's apparently in some kind of limbo if he's in the job at all anymore, and he finds himself a criminal defendant as a person charged with a crime. And now he finds himself as attorney for the defense because he's apparently representing himself pro per as his own defense counsel and apparently doing a good job.
I think at one point there in the cross-examination of Cindy Blitzer, the wife of the cooperating defendant, he's trying to get her to say, hey, look, you had somebody else taking your nursing exams on a state computer terminal at work. So not only was she getting paid while not working, she was having other people in the office do her homework for her and take her exams. That's the accusation. She wouldn't admit it on the stand, even though the people who did the work basically said that that's what was going on. She's not agreeing with it. I think that the questioning there needed to be a lot more specific. He needed to really break this down. When people start to stonewall, David, look, you've got to break the questioning down. It's got to say, okay, let's talk about your exam. There were a number of questions on it. Were there 100 questions? Were there 50 questions? Okay, so once we arrive, let's say there were 50 questions. Who did question number one? Whose fingers were on the keyboard? Right. Whose fingers were on the mouse? Was the chair directly in front of the computer? Who was sitting in it? Where were you sitting? Were you sitting or were you standing? And just break it down finally, I guess is the word I'm looking for, and force the answer, because if her answer doesn't line up with the other people who said, yeah, it was really me answering the questions, it's going to just destroy her credibility.
Well, you see this so often in court, and you do wonder why the government sometimes makes deals with some of the cooperators that they do, because the best version from her, apparently, is that she not only has kind of a no-show job, she's doing no-show work, or she's doing work that's really not relevant to her office. But as you said, she seems to have a tutor on the payroll. She's not charged with anything. She's got a husband who apparently is being treated very, very lightly. And I haven't seen his plea agreement or don't know the case in that much depth. But you always wonder what the plea agreement says. Normally in federal court, they leave it completely up to the judge to determine how much you ought to get. But a person who's not charged isn't going to get anything. She's not charged. Apparently what her husband's going to get I don't know. I guess I just don't know the case, you know, with all of its intricacies. But it's normal that that's up to the judge. And one of the reasons it's up to the judge is the judge can be kind of a lie detector. The judge can sit there after hearing all the testimony and think, you know what? You at least came in here, showed remorse, and told the truth. Or on the other hand, you know, I was very unimpressed, and you did not seem to really level with the jury, and that's going to count against you. But I don't know what the situation is exactly with her husband. I know with her, she's not charged at all.
Yeah, this is certainly an interesting case. I mean, it's a soap opera, it's official corruption, it's official misconduct, whatnot. So we're going to continue to break this down when we come back here on the Law and Crime Network. But first, I want to bring you up to speed on some of the top legal stories making headlines across the country today. That was testimony from Craig Blitzer, the cooperating witness in the Wallace Bradsher official corruption trial in North Carolina. That witness and the defendant were neighboring elected district attorneys in different judicial districts in central North Carolina. The defendant had hired his wife. He brought her over from his private practice. He ran on the platform, according to his opening statement, that he was going to bring his successful private practice team into this elected office. So he brought his wife, who was part of that team. Well, bells started going off with ethics authorities when that witness, the neighboring district attorney, tried to hire his own wife. The allegation is that the two men, that witness and the defendant, decided to, from an employment perspective, swap wives and crisscross employment. So that witness hired the defendant's wife. The defendant hired that witness's wife. Look, this is complicated to break down. Thankfully, we have David Katz along with us here on Law and Crime to sort of break it down. Look, we were just saying that we're not convinced that the prosecution's case is really strong here because they seem to be going full throttle after the defendant, and yet the story that we're hearing from these cooperating witnesses who were involved in this seems to be sort of falling apart. We just had Cindy Blitzer on the stand, and she's saying, well, I was going to nursing school while you were hiring me, but you didn't give me any work, and that's just the way it went, and apparently that was okay with you. And then the defendant's like, oh, really, it was? How do you know that? Well, because my husband told me. So then it's like, well, is the husband lying to the wife to cover this up, or what's really going on here? I've got questions about hearsay getting into this thing, but look, why no objection to it? My guess, and tell me if you think I'm wrong, is that no objection because the defendant is hoping that these two cooperating witnesses basically hang themselves.
I think you're really onto something there. I think that there is so little point, at least to some of this testimony that we've seen, to help the prosecution's case, that it may be that they're giving, the defense is giving the prosecution enough rope to hang themselves. I mean, I prosecute a lot of white-collar cases. I defend a lot of them. And you usually see a much stronger presentation by the prosecution than at least what we've seen so far. And usually there's a theme. You kind of wonder what the theme is of this. When the fellow has run for office, he's been elected on a platform, he's going to run it like his law office. The people know he runs his law office with his wife working for him. He has a wife who's working for him. He has a legal opinion, apparently. It would be nice if it were inviting, obviously. That would be prudent. But he's going to have evidence that he has a legal opinion saying that he could do this. This other fellow, the one who got what looks like it's a sweetheart deal, because the fellow's a pilot, no one would want to give up their legal license. But if you're a pilot and you want to go fly around, giving up your legal license is not the normal sanction that it would be. It doesn't seem like he's going to be punished criminally. And he seems to have this story that conveniently it's all the other DA's fault. It's not him or his wife's fault. And of course, those are the two people that we just heard from. And the whole thing just seemed very mushy.
Yeah, look, let's talk about what's going on with Craig Blitzer's outfit in court, because when he first sat down, I'm sitting there saying, what is up with this? I mean, he's got on what looks like a jumpsuit. He used to be a defense attorney, and then he was an elected prosecutor, and he doesn't show up in a suit and tie. He shows up in this thing that looks like he's out there directing air traffic. Well, this has to be deliberate. This guy has been in courtrooms for years and years and years professionally. He knows that how people walk in, the demeanor, what they're wearing, sends its own message. What message is this guy sending?
Well, they seem to be sending a message, and this can't be accidental. This has to be with the cooperation of the prosecution in this case, how they want his appearance to be, how they want him to come across to the jury. There are experts, as you know, who just specialize in how people ought to look. in court. So this looks like a sort of an anti-lawyer, don't look like a lawyer. This is the prosecution saying, don't look like a lawyer. The bad guy in the courtroom is the lawyer. We want to convict a lawyer. This guy isn't really a lawyer. He's something else. He doesn't even look like a lawyer.
Does this work with juries, or do they see through it?
You know, I don't think so, but there's still a lot of people who are very superstitious about clothing. There's a lot of people who think that Martha Stewart wouldn't have been convicted if she didn't have a $12,000 handbag with her. There's a lot of people who think if you're really poor, why do you have alligator shoes on? So there's a lot of things that go into how jurors look. And he's definitely trying to look like he didn't used to be a lawyer, and he's not a lawyer.
I agree. I'm trying to figure out where this is all going to go. I'm trying to figure out who was really driving the bus in this alleged scandal. Was it the defendant, who you just saw sitting in the chair, or was it the cooperating witnesses, Craig Blitzer and his wife, Cindy? They testified. We're going to have more testimony in a second. It looks like the jury is heading back into the courtroom. It doesn't look like another witness has taken the stand yet, but they are officially back from this mid-afternoon break. So, David, look, I'm hearing a lot of people in the chat room and whatnot saying, you know, we really don't like these cooperating witnesses. Maybe they're the ones that should have been gone after a little bit more strongly. We'll hold that thought, though, because we've got another witness on the stand. We're going to go to that now live. This is Tyler Henderson on the witness stand. He is an employee, it turns out, at various points in time of both of the former district attorneys who are facing charges in this case. Of course, one of them, Craig Blitzer, wound up getting off relatively scot-free because prosecutors agreed to more or less not punish him in return for his testimony against the actual defendant in this instant matter, that defendant, Wallace Bradsher. This is a real soap opera, and look, I'm trying to unravel it all because all of these folks are pretty much working for one another, including the wives of the two district attorneys and including this witness. He's working for one guy and then working for the other guy. And I think the key point that we got out of this, David, is that this witness said, the defendant, Wallace Bradsher, told me to go tip off my boss, Craig Blitzer, that the State Bureau of Investigation was closing in on his wife. Is that request, if we're to take it as fact, as testified to by this witness, that there was a request for a tip about an investigation to one of the subjects of that investigation, is that enough for the state to make out one of the obstruction of justice charges here?
Well, there are obstruction of justice charges here, and it might very well be that that's the underpinning for this charge. But it's very unclear exactly what the tip-off was. If the tip-off was just let them know that there's an investigation going on, but not to say some particular thing, like we did X when we really did Y, you wonder what the real obstruction of justice would be. But of course, that's the idea. You know, we always hear this word collusion now. You know, was there some kind of actual collusion? Did the defendant actually do something or say something that would constitute trying to obstruct justice? Because you don't have to succeed in obstructing it, but you do have to try to corruptly influence the investigation. So I'm waiting for the words where the corrupt influence attempt was made supposedly by the defendant.
I'm still waiting for that as well. And exactly when did it happen? There's these accusations that there was a car ride and that the two of these guys cooked up this scheme. There was additional discussions at a pizza place. But let's talk about conflict of interest as well, because, you know, attorneys have to realize, you know, if you represent somebody as a private practice attorney and then you get elected as the prosecutor, you can't go prosecute the person you used to represent. And it seems like a lot of this horse trading back and forth where one wife is working in one office and then in the other office, and then this guy is back and forth between these various offices. It sounds like this is for some reason considered ethical in North Carolina. In a lot of places, this would be raising red flags, or at a minimum, people just wouldn't try it.
Well, let me just say, as a criminal defense attorney, I think it's great that the public is electing criminal defense attorneys for various positions, including to be a district attorney. Some of us criminal defense attorneys would be excellent district attorneys. We'd understand where the defense was coming from, and we'd make sure that we dotted our I's and crossed our T's. But the problem that you outlined is that these criminal defense attorneys have existing clients. and they can't go easy on them, they can't go after them, they can't do anything with them. So this is partially an effort to have the conflict cases handled by the other office. But I also haven't heard any evidence that, for instance, the wife of one of them handled a case that her husband couldn't have handled. That this was not, in other words, a runaround of a conflict problem. This wasn't an attempt, although it would be imputed to the wife, to avoid that. So I really don't understand where they're going. If there's a particular conflicted case, they ought to say, okay, the XYZ case was a conflict case, and by having your wife work in the other office, you ran around a conflict that you and your wife had with regard to it.
Well, that's one of the accusations I think that's been on the table here, is that some of this was a wife working in one office and handling cases that her husband couldn't handle, vice versa. That's been hanging out there. They haven't gotten into a lot of detail about it because it doesn't seem to be the subject of an instant criminal prosecution. Okay, that's all professional conduct rules that would be dealt with, I don't want to say privately, but it wouldn't be dealt with in a criminal court. It would be dealt with in a professional conduct hearing involving that attorney. But that seems to be one of the undercurrents underneath this case, and that's a little bit disturbing too. Because look, if you have a client, an individual in the community who can't be prosecuted by the husband, then why is that husband with the conflict's wife touching that client's case? You know, something about that just doesn't smell right, and there's this weird undercurrent in this case. But look, we've got this witness on the stand. He worked for both of these guys. He allegedly was asked by the defendant, as he testified, to tip off the other district attorney that investigators were closing in on that other district attorney, Craig Blitzer's wife. Let's go back to the testimony. And we are at the end of the day in the Wallace Bradsher official corruption case in North Carolina, the case of a former elected district attorney who, by the way, used to be a defense attorney. Well, guess what? He's sat in the prosecution chair, the defense attorney chair. Now he is sitting in the chair as the defendant. Look, we have attorneys all over this courtroom, it seems. We had another former prosecutor sitting in the witness chair and in the defendant's chair. They're all over the place here. And the accusation, of course, if you've been watching us, is that there were these two neighboring prosecutors. They were elected district attorneys. The defendant, Wallace Bradsher, had brought his wife over from private practice to work in his office as district attorney. 4 years later, his neighboring district attorney wanted to do the same thing with his own wife. The ethics people caught on to it and said, this shouldn't be going on. The accusation is that they swapped and hired one another's wives. From there, everything allegedly went downhill. Some of the questioning at the tail end of that, though, just to bring David Katz in here, criminal defense attorney, who's visiting us all the way from Los Angeles. The tail end of this was getting into this paperless discovery and why that needed to be brought in. We keep hearing this woven into the testimony. There's this paperless discovery coming in. One of the undercurrents of this is that there was someone who was screwing up the old system where files would come in from a police department or a sheriff's department, and then those files have to be given over to defendants in whole or in part, depending on jurisdiction. But the relevant stuff has to be given over to a defendant so a defendant can mount a defense.
Well, that's a fascinating part of this, and part of the defense here, and it seems to actually have some foundation, is that he's a crusading defense attorney. He runs for district attorney. He becomes district attorney. He wants to shake up the old system where discovery, including Brady material, information that would be exculpatory and that would help a defendant, he wants to make it fair. He wants to make sure that gets turned over. And apparently there's somebody, according to the defendant, who's a lawyer, that has someone in the office that is not cooperating with discovery and not helping defendants get a fair trial, and that this person, according to the defense, had it in for him and somehow has tweaked this investigation against him to go forward. Now, having said that, it might have been a perfectly valid investigation, but his argument is that it was not a valid investigation. He didn't do anything wrong, and it was tweaked against him. And that's, of course, very important because there are prosecutors around the country who don't share discovery the way they should. And there's a whole national issue about Brady information, exculpatory information that helps defense counsel defend the client, helps innocent people not be railroaded or found guilty when they shouldn't be. And there are instances all over the country where that discovery is not shared with defense lawyers. And as they just said right there, digital discovery can make that easier by keeping a footprint. Before that, it's all these papers, and the prosecutor says, I didn't get them, and the police department say, oh, that went to the wrong place, and this and that and the other thing. We didn't think that was important. So this is a very critical issue that's just raised its head in the middle of this cross-examination.
Yeah, it's another one of these situations flowing under the currents of this official corruption case that we're watching from North Carolina, where the defendant, Wallace Bradsher, who used to be the elected district attorney, is saying, I've been thrown under the bus by someone I had to discipline for not taking proper care of files that needed to go to defendants. He's saying that that person was under his thumb and that that person sort of drove investigators to dig into him in some act of self-preservation or spite or something like that. That was what this defendant said an opening statement. We're going to wait and see how this plays out when this case picks up tomorrow. We're going to keep talking about this for a couple of minutes before we wrap up, but first we want to get you caught up on the top crime stories of the day, so let's go to that first. And when things pick up at 9:30 tomorrow morning, we will be back live in the Wallace Bradsher corruption case out of North Carolina. This accusation that one district attorney and a neighboring district attorney conspired in some way to hire one another's wives. Then one of those wives stopped working to go to nursing school. Well, that wife was on the witness stand earlier today. And David, a lot of people in our chat room sitting there saying, we really don't like this woman because she's fudging whether or not she felt that she really did something wrong.
Well, it does look like she received a paycheck and she went to school at the time, and it also seems like they kept someone on the payroll. The taxpayers were paying that person to be her tutor. So, and on top of that, she didn't get prosecuted for anything. So, and her husband seems to have gotten a pretty good deal in this case, and I'm sure the defendant's position is that the two of them were more at fault for this, maybe solely at fault for this. And we'll see what happens with whether there really is a basis for this tip-off. The tip-off thing would not be good if it plays out against the defendant, but he's an attorney. I'm sure he's going to say I was way too smart to not do that. And it looks like he has a former fellow who worked for him for about 10 years, who looked like at the end of the day was a pretty sympathetic witness for the defense, not for the prosecution, which called him.
Last question here. Cindy Blitzer, the woman who was cashing the paycheck while she was going to nursing school, was up on the stand earlier today and for some of yesterday, and she's basically saying, well, Mr. Defendant, you weren't assigning me cases and I was getting paid, and, you know, my husband said he talked to you and he told me to keep doing it. Should we trust that that's the way this really went, that it went from the defendant to that witness's husband and then back down to the witness? Or is it possible that it was the witness and the husband who are kind of driving the bus here and they're trying to loop in the defendant, even though he's not horribly culpable?
Well, I was an assistant United States attorney for 6 years, and when you are actually going to prosecute a case like this and you're going to take the position someone is guilty and ought to go to prison, which is the position they're taking as to this former district attorney himself, you got to make sure that you really have some evidence. So I would look for here, if I had been prosecuting this case, is there a tape? Is there some record? If they knew this thing was coming and it had been tipped off, why wasn't there a recording? You could have somebody go in there on a sting, find some kind of evidence that's really going to corroborate. You know, obstruction of justice is very easy to charge, as we hear in the news all the time. Easiest thing to argue, obstruction of justice or collusion or something. Where's the proof? Where's the beef? Where's the evidence here?
Yeah, this particular defendant facing 7 charges. We're going to pick up with that case tomorrow. For now, though, David Katz, appreciate you joining us here in our studios in New York.
Well, it was a pleasure being here from Beverly Hills. Thank you very much.
Shifting coast. So oftentimes we have guests from everywhere on Law and Crime. That, of course, continues today. Again, we'll be back on the air live tomorrow starting at 9 a.m. We are expecting testimony to pick up at 9:30. For now, this is Aaron Keller, and for everybody here at Law and Crime, have a good evening. We'll see you tomorrow.